How are we? Sorry about the small delay. I started talking to you and I talked all the shit after a countdown. We weren't live. Okay, that's very on brand. I am in one heck of a mood. It is Wednesday, June 11th, 2025. And we just wrapped up day 31 Commonwealth v. KarenRead. Okay. The defense has not rested, but we had some wild moments. And the only person who could talk us off the proverbial ledge is our best friend from out of town, the attorney to the community of Free Karen Read and the aunties, because they all watch him. It is Mr. Mark Bederow. Hi,
Hello.
Mr. Bederow.
How are you?
I'm great. How are you today?
I'm good. Nice to see you.
Always a pleasure for me to see you. Now, I don't know how I picked the small straw and somehow have canoodled to get you to come to my house on this very day. But I am thrilled and I need you to talk all the shit with me. I want to know every single thought of the Hank Brennan breakdown heard round the world and Dr. Rentschler just knocking it out of the park.
Okay. So first of all, you got me because you asked. You asked first. So you see how that works? You shot your shot, whatever they say. So here I am.
Yes.
Short of a miracle with the jury, which, jurors can do whatever they want. You don't know. But short of any kind of shenanigans, this case is over. I mean, it is, the amount of reasonable doubt in this case is overwhelming. And what you saw today was the complete recognition, acknowledgement, and quitting, essentially, of Brennan. Okay. His tone in cross-examination of Dr. Rentschler was just pathetic. It was antagonistic. It was petty. It was obnoxious. You've seen it before with other witnesses, but it was flailing. If he had nothing to cross-examine, he shouldn't have cross-examined at all, or should have wrapped it up in 30 minutes instead of challenging somebody who is much better at this subject matter than he is and who just destroyed him on cross-examination and made his opinions that much stronger, made the defense case that much stronger. And it's so bad with what Rentschler did to Welcher, very politely, by the way. He killed him with kindness, but if you watch and you pay attention, he was basically saying that he's a fraud. Without calling him a fraud, that he did no scientific analysis. He did nothing. He had no methodology. He didn't do any testing. He didn't do any analysis. He's citing studies that are not only inaccurate, but from 1970 something. And, the SUV didn't even come into existence until after that. So the whole design of cars and the body shape changes, which of course is important. The way they played that video and slowed it down and showed this clown lean into the car, the way he explained that even the paint, what does that show you? That just shows you, a potential, from A to Z where it could have been, but there's no measurements, there's no pattern analysis, there's no anything. Obviously, the X-rays are a thing that are a big deal and came out. The wound patterns in the wrong direction. The fact that, in order for John O'Keefe to go in the direction he went in on a clipped hit, that the taillight pieces would not have gone in that direction, that the physics don't support it. 9 holes versus at least 36 unique occasions. I mean, you can go on and on and on, and you could see in the cross-examination, Brennan knows, and lawyers know, when something in real time is going really well, okay, or really bad, and you try not to think like that. Obviously, you don't want to get lost in what you're doing, but when you're circling the drain, you know when it's just not working, and you could see it in his petulance, you could see it in his demeanor, you could see it in his lazy questioning.
Oh,
he basically was inviting the witness to offer his explanation and opinion that there was no impact, and this doesn't make sense, and that I don't care about taillight pieces and glass unless and until I'm satisfied that the physics and science and kinetics and engineering supports a collision.
right.
Because that's the scientific method. That's what your guy didn't do. He relied on the taillight, the story, and concluded there was an accident and then tried to explain it. Where what this real witness said was, I need to determine whether there's an accident in the first instance, and then we can get into the other stuff. And if there is no evidence that even supports a pedestrian SUV strike scientifically, then everything else means nothing to me. And why Brennan would invite that analysis makes no sense. And you've seen over the past 4 or 5 days, they have stacked witness after witness after witness who has just systemically demolished their case. I mean, and it's going back several witnesses. I mean, think about the last 5 or 6 witnesses that they've called. Think about
Right.
the medical witnesses, Dr.
Yeah.
Russell, unimpeached, no question, not consistent with the car accident. These are dog bites. Lo Posada, who I'm sure you'll want to talk about later,
Yes.
destroyed every fundamental scientific principle that arguably is an issue in this case in favor of the defense. Obviously, Wolf and Rentschler, the engineers, who did a 1-2 punch on why this doesn't make sense from an engineering standpoint about the accident. The taillight doesn't match. John O'Keefe's injuries don't match. The hoodie doesn't match. His location doesn't match. Nothing matches. Think about Officer Barros. Absolutely not. Did that taillight look like that? Think about Lucky Lawfren, who is adamant, unequivocal, no body out there. I mean, you go on and on and on, and you sit here and you say, never mind reasonable doubt. I mean, if they were the prosecution, you would be arguing maybe they proved it beyond a reasonable doubt the other way, that there was no car collision. They don't need to do that, obviously. And I expect they're going to absolutely annihilate Brennan and Welcher and Burgess in summation, who are really at this point all they have. So the x-rays, for example, right? They didn't get a chance to directly confront Welcher, but it's evidence. Okay, they're going to read from his transcript what he said, and then they're going to hold up the x-ray and what it shows and say, what are we doing here, right? I mean, I would expect that they are going to attack Brennan personally, not personally in a personal attack, but that he tried to sneak in that evidence with the hoodie, and it's totally appropriate for them to say that he tried to snooker you. This was on purpose. They try you. We know based on this. Now the other issue they have to deal with is because there is no rebuttal case, and they're not calling Hartnett either. They got to get those reports and evidence. Remember, they were going to come in through her.
Yes.
But he didn't want to subject her to that questioning. Why is that? Is that because he's afraid of what she might say about the cutting?
Yes.
Welcher. Why didn't they want to subject Welcher to this questioning? Might it be that Brennan is afraid what he might say about the x-rays.
Yes.
I almost wonder if this is a form of a conflict of interest where Brennan is more concerned about his own rear end than the case, and whether these witnesses, if called, would blow him up personally and make him look implicated in the stunt with the hoodie and prove his knowledge, make him implicated in the stunt with the x-rays and give him personal knowledge. Now, by not calling him, the jury's never going to know that. By not calling Hartnett, the jury's never going to know that. Maybe I'm wrong, but if he's thinking about his own rear end rather than the case, that's pretty fascinating too. But either way, whether I'm right or not, you can see that the problem after problem after problem, and that this case is just complete. The wheels have completely come off. The train is over the cliff. They've got nothing.
Yes.
They've got absolutely nothing. They don't have a scientist that supports anything they've said. They don't have a manner of death. They don't have proof of an accident. They've got nothing. They've got two experts, one of whom has academic fraud issues, corrected his data in the middle of trial, doesn't know the difference between bits and bytes, who fed another witness who finger paints and leans into a car, and that's what they got for $400,000.
Finger paint, but seriously, yes.
So basically, the taxpayers in Massachusetts, between the $1 million they got for the prosecutor without a conflict of interest, the $400,000 they got for Aperture to do nothing, and all the other expenses, you people got fleeced.
Yeah. Yeah. And it's shameful. Like, that's the thing, is that today, in my opinion, and I don't think that you would opine to this, but I feel as though Hank Brennan has been dangerously teetering on a line of prosecutorial misconduct. And I think that Attorney Alessi absolutely went for the fences when he said that by bringing up those holes and that were created by the criminalist from the Commonwealth themselves, from Mass Crime Lab, you know, today, again, in the questioning, in the way in which he went about addressing Dr. Rentschler and his inability to sit in line as a prosecutor, Mr. Bederow, it is mind-boggling to me. I don't think prosecutors by nature, Adam Lally sure as hell never would have behaved in the manner in which he did. And it was shocking to me to see Judge Beverly Cannoni completely, in my opinion, lose control of our courtroom today.
I think the judge embarrassed herself today. The fact that a defense lawyer had to get up and demand that you take control of your courtroom and do something. By the way, I think it was totally appropriate. I mean, that's what zealous advocacy is for a client you're representing. And sometimes you have to go, ways that you ordinarily wouldn't go.
Yeah.
And I think it's very important for the jury to hear that these people have had enough. Okay. She's just not, judges should not tolerate the petulance and behavior and just the snivelly attitude and the constant needling that you get from Brennan. And I think that comes from somebody who spends the majority of career, I tweeted about this earlier, cross-examining, cops that he believes are corrupt, dirtbags, criminals, cooperating witnesses, people that cut deals, given the way, his normal practice and who he deals with, he's used to just bada beep, bada boop type of cross. But Dr. Rentschler, La Posada, Lucky Loughran, Dr. Russell, Dr. Wolf in particular, these are not the kind of witnesses that you bada beep, bada boop and be obnoxious with.
Right.
And he showed himself, he's been exposed, and, he owns this. Okay. This is what he wanted to do. He apparently put on his best case, whatever that is. and they got, in the last
Thanks.
week particularly, absolutely annihilated.
Yeah. Demolished. Absolutely. I wanted to ask you, as somebody who's not in the courtroom, I have gone, I got to go twice, thank goodness, because it was very interesting to me how the interaction between the jury watching the lawyers. I was wondering today, by Alan Jackson, AJ getting up, the zealous advocacy in which he had to demonstrate because it was out of hand. Okay. And, Judge Cannoni did say just questions, to Hank Brennan. But when he got up and said he needs to be admonished, and she budged, and she budged to Alan Jackson. As somebody who likes to take things in and is a people watcher, as a freaking professional, do you think that impacts the jury of, yes, you do see Alan Jackson, coming out in a way that you don't want to have to, but when he did, he got the result. And although it might have not been the admonishment he wanted, but she was bending Mr. Bederow in ways we have not seen her thus far.
I don't know if it's so much the result, because I don't know that she did that much and went right back to doing what she was doing. But I think it was important for the jury to see, somebody get up, basically say, what's the famous quote from Network? Like, I can't stand it anymore. I've heard what I need to hear and I can't take it anymore from Network. I'm getting old. The movie Network? No.
I don't even know the movie.
Some of the older people. It's from the 70s. Anyway, the point is, I think it was important for the jury to hear the lead attorney get up for the defense and say, enough of this shit. This is absolutely ridiculous. And it really doesn't matter at that point what she rules. The jury sees it. The jury hears it. And I think they say, we've been thinking that. We recognize that. We see what's going on. And in many ways, it's validating for the jury. It's validating. And it really doesn't matter what she does at that point. It's telling the world, I'm mad as hell. That's what it is. I'm mad as hell and I'm not going to take this anymore. That's the quote. And that's essentially what they did. And it was necessary. I mean, this has become ridiculous with the rulings, the objections, the behavior by Brendan, the snivelly comments. And, he sees that we're at the end of the line here. It's basically over. There's nothing else for him to do other than sum up.
And do you think that was, though, his kind of, when you say he's throwing in the towel, it's not quiet quitting, it's like loud quitting. Okay. It's the exact opposite of, the workforce and normal people. But
let me paraphrase. Not quitting. That's not fair. I guess let me. No.
Oh.
He recognizes we're losing. We're losing badly. There's nothing I can do. It's inevitable. Okay. And what I mean is not that he was quitting by not putting on a rebuttal case, but if he puts Welcher up there, he's going to get just killed up there.
Oh, yeah.
Okay. And I really start to wonder if he's caught. He's caught on the hoodie. Is he caught on the x-rays? These are things that should never happen in a case of this magnitude with this many lawyers. They've been so prepared, so meticulous. And you wonder if there is a fear factor. You really do. That if I let these lawyers who smell blood in the water come after Hartnett and come after Welcher, not just on the case, but just about, let's talk about when you cut that and made your report. And did you talk to Lally? Did you talk to Brennan? And the same thing with with the hoodie, as well as the x-rays, that he starts thinking, I don't want those answers, because on top, I've already lost this case pretty much. But beyond that, I don't want this coming back to me. And the best way to keep plausible deniability, if that's what this is about, is not have them on the stand. Now you'll never know. Yeah. But come summation time, you better believe, like as it relates to the hoodie, that they're going to drill down and point the finger at Brennan. They certainly should.
Yes.
They're not trying to fool me, ladies and gentlemen. Brennan is trying to fool you. Let him object. Who cares? It's true. And as far as the x-rays, you bring out the fact that those x-rays were taken at autopsy. Ooh. They're in evidence. They're dated January 31st, 2022 in Sandwich, Massachusetts, where the ME's office is.
Yep.
They were part of the ME's report. The prosecution has had them for more than 3 years. And you heard this guy, this finger painter who got $400,000 come up here and say that I reviewed all these important materials and did all this work. And I looked at the autopsy report. He never mentioned the x-ray. And by the way, the single most important x-ray, I mean, the right arm is the point of impact. It's the whole case. Yes. And are you telling me that he never saw that? And that only can be, I said this earlier, there's really only a few possibilities. So when he looked at the autopsy report, they can read his transcript. And he said, as far as I know, there were no x-rays of the arm, so we don't know.
And he said there was x-rays, though, of the sternum, right? Yeah.
So what he's saying is, I looked at x-rays, but not that. So what someone like Alan can get up in summation and say is, we know that's absolutely, positively not true. We know that this self-professed expert who looked at everything and was so focused on Karen's interviews and photographs, claimed he looked at x-rays and that there was no x-ray of the arm. Did he ask questions? Now, to me, this is why they may not want to recall him, because he gets up and he says, I didn't see x-rays. And you say, well, it's all about the arm. When you looked at the x-rays, this is the pretend redirect, right? The pretend or recross. You knew that the arm injury was the major point of emphasis for your analysis. I mean, we use finger paint. I mean, this is a big deal. And you saw the x-rays and it was missing the right arm, and that didn't stick out to you. Did he ask Brennan? Was he told it doesn't exist? I don't know. I don't think Brennan wanted these people exposed to this, but either way, you say this guy claimed he was prepped, he was prepared, and that there was no x-ray. It's not true. And that undermines everything he told you about the arm. And this is the same guy who told you that based on a study from 50 years ago, head was the most common area of vehicular impact. That hasn't been the case for years. There weren't even SUVs. That's the only article that he cited. You could go on and on and on with this guy and compare him to Dr. Rentschler. And really, intellectually and personality as well, you're talking men amongst boys. I mean, it's that different. The dichotomy between the level of expert. Not only that, expert A was hired by a neutral party and made roughly $50,000 for his firm, but only makes salary.
Yes.
Expert A did all these scientific evaluations, talked to you about kinetics, physics, blah, blah, blah. Expert B was paid for by the prosecution for the second trial. He replaced Trooper Paul. Right. Expert B and his firm were paid almost 8 times the salary or income of the other one. Expert B did no science. He finger painted. Expert B changed his opinion mid-trial because he relied on the data of his colleague, who on his own is telling you, I changed it mid-trial. Expert B's colleague didn't know the difference between bits and bytes. Expert B's colleague has probably been engaged in some form of academic dishonesty for the better part of 17 years. Oh. We don't even have a burden of proof here. So you may be asking yourself, why are we here at all? You haven't even talked about the medical examiner, the pathologist, the dog doctor, all these other things, Barros, Loughran, the credibility problems with some of the prosecution witnesses, not calling Michael Proctor. I mean, you could go on and on. You have no burden to prove. This is as strong a reasonable doubt case as you'll ever see in a murder case that's brought. You don't even have a manner of death. Now, this is not something the jury's going to know, but I would challenge anyone to go on Westlaw or LexisNexis and find another case, murder case, that was ever brought where the medical examiner told the prosecutor, I don't know how this person died, basically. I mean, manner of death, put it in English. They're basically saying, I have no idea. Could have been an accident. I have no clue.
Yeah.
And they say, charge on, let's just file murder charges. This is...
Well, and the scary thing is, for me, is looking at everything and you have the totality of the evidence. And that was such a bullshit line, in my opinion, pardon my French, everyone. But from Hank Brennan today to try to come back at Dr. Rentschler and say, well, let's have some common sense here and the totality of the evidence. And that is a very, very Commonwealth and man who lives in an attic saying, okay, that you can't just look at this in a vacuum. And because I would always say that Officer John O'Keefe's injuries, it never made sense to me that he was struck by a vehicle. Now, this is not biomedical information. Why? Because it's way above my pay grade, the physics and the forces. Like, are you smarter than a 5th grade physics human? No, I'm not. However, when I looked at that, and Officer John O'Keefe's body has always told us, and that for me was huge, hearing from Dr. LaPosada on the stand. I've said that in how many videos, and I said, it doesn't matter what KarenRead said. It doesn't matter what Jennifer McCabe said. I don't give a shit about anything other than what the story was told to me by Officer John O'Keefe. And when we got those films yesterday, Mr. Bederow, I nearly lost my mind. Did a lap around the block, was like, as soon as I see AJ holding him, you know me, I lost my mind. I was like, oh my God, there's x-rays. We have the x-rays. The x-rays have entered the chat. It was life friggin' affirming. I go, if she says right now that there is no hairline fracture or anything to his right upper extremity, that video that every dickhead on the Commonwealth side that says, we're winning, we're animal blood, I'm Tiger Blood, I'm fucking Charlie Sheen, shut up. They think they were winning because they had Rescue Randy, which is so rude. And they, saw him do a pirouette, but you also saw his arm almost be ripped off his body to break that taillight. So if there was no fracture, then you're telling me that Officer John O'Keefe was struck only in the arm at 24 miles per hour, because why? That's what you told us. That was your whole story, Commonwealth. But that a human being would be struck at that force and have not a fracture, a break, or a bruise. You've lost the plot. There was no injuries, no even soft tissue injuries. And I know there wasn't an MRI done, but you can see that. And Dr. LaPosada said that, yes, I can't tell you about ligaments. I couldn't tell you about tendons, but as it relates to swelling, we would have been able to see that swelling. And damn right well, I was pulling up those pictures, making it as high quality as I could today when Dr. Rentschler had them on the screen. And yes, the opacity was a little bit, it's too white on one of them, but the upper brachial, you could 100% see everything. And it was all intact and no swelling. Case over, close this, send us away.
No, it's hopeless for them. It is. Again, barring things that nobody wants to think about that should never happen in a trial. I mean, you even had Dr. Rentschler methodically explaining that somebody who gets in a car accident and puts their arm up could get some kind of fracture from a freaking airbag. But watch that video of 24 miles an hour of the arm dangling out there and just getting whacked. Watch it contort. Watch their knuckles contort.
Nice.
And there is nary a bruise, a tissue damage, fracture of any sort.
Oh,
10-year-olds can understand that.
yes.
And you pile on all these other issues, and you say, you know, the people who go crazy and tell you things. The bottom line is they don't teach a very important concept at the Twitter law school, and it's really important. And it is very repetitive. It probably people are sick of hearing it, but it matters. Criminal trials in a courtroom have rules, and rules include burdens of proof and proof beyond a reasonable doubt. And they don't teach those concepts at the Twitter law school. They just don't. So everybody says, oh my God, I saw this video and there was taillight fragment. So, you know, I told you it's over. Why would they do that? Why would nobody at the defense team say, what are you doing? And it's so obvious that at Twitter law school, they teach checkers and, you know, real lawyers play chess. It's just, there is so much reasonable doubt. It's not worth getting excited about. You know, the trolls, they get triggered, or whoever, or the people who want to yell and scream. But what mostly will trigger them is when you tell them, how are you ever proving beyond a reasonable doubt when you literally have evidence of nothing that supports a car accident? Now, I don't mean that they don't have any evidence that they can scream and yell about and say, oh, well, you know, the text stream data shows that she had to have been going 24 miles an hour in front of the house. Suppose the jury goes into the jury room and says, well, wait a minute. Some juror says, let me play devil's advocate. And I think that happens a lot. You want to be fair to the evaluation. And to some extent, you're thinking we owe this to John O'Keefe to, even if we know he's a loser, to really be sure. So somebody plays devil's advocate and says, well, you know, we think that there is compelling evidence that she slammed the car at 24 miles an hour at around 12:30, whatever the time was, in front of Brian Albert's house. Mm-hmm. Okay. And you say, well, okay, that fact supports the prosecution. Okay. Now plug that in with Rentschler, Wolf, La Posada, Scortibello, Russell, Barrows, Loughran, and you sit there and you say, you're not even considering that maybe that didn't actually hit him and cause this? Like, it's not even possible? It's not even possible. Like, in other words, we're dismissing that out of hand. And we're not going to factor in the fact that Jen McCabe, remember her from like 3 months ago, changed her story about the last time she saw the SUV and the butt dials. I mean, her butt dials, not the ones that are not in evidence. You know, they're not going to worry about that. Well, what about I hit him, and there's no corroboration of that? That's powerful evidence. Mm-hmm. You know, the fact that Kerry Roberts lied in the grand jury was supposed to corroborate something, and it instead didn't. We're not going to worry about that. The prosecution tried to tell us that Jen McCabe cooperated with law enforcement and was so concerned about things. We're not going to worry about the repeated lies to the FBI, followed by the immediate termination of that interview. Does that sound like cooperation? The family text chat, you know, about tell them the guy never came in and they're looking over here. We're not worried about that. We're going to dismiss Officer Barrows, who has no reason to lie, right? Literally zero. Because he got tripped up on when he saw the photograph of the taillight from the state police. The fact that the lead investigator was terminated for bias in this case. And they didn't even have the balls to call in this very case. And they concealed that. They didn't even have the balls to call him to confront this. Beyond a reasonable doubt, there is no chance short of corruptive process in the jury, which I'm not accepting will happen, by the way. But if you just look at this as an exercise in if a jury follows the law, this is not anywhere near even a close call in what the outcome here is. There is such a dearth of evidence that establishes that Karen is guilty of any of these crimes. In fact, the best fact for the DA that they've proven is that she consumed alcohol.
Yeah.
Okay, they've proven that. I mean, let's be honest, they've proven that.
Well, I trust my woman in STEM, Karina Kolakithis, who told me that she was in good condition.
I said consumed alcohol. I didn't.
Yeah.
And their evidence that she was, over the limit. There's two ways to be over the limit. There's the statutory, 0.08 way.
Correct.
They claim they did that, but that's kind of a questionable, extrapolated circumstance. But then there's also what they call like the common law way. Somebody just has every indicia of being intoxicated. They smell like a brewery. They're tripping all over themselves. They're bloodshot, watery eyes. She's got none of that.
None
of that. Okay. No. But proving that she consumed alcohol doesn't help you if you have, never mind reasonable doubt, essentially decimated the prosecution's claim that she created a pedestrian collision, then it doesn't matter what else she did. And they've got to explain that, obviously, in the concept of reasonable doubt, but that if there is reasonable doubt as to the physical act of her backing into John O'Keefe, you can stop deliberating right there. Nothing else matters.
Nothing. Not a thing.
Nothing. Her intoxication at that point is legally meaningless.
Correct.
So, and they will focus on that. No accident, no crime. Period. Full stop.
Yes, absolutely. Mr. Bederow, can you hear me? Can you hear me okay?
Yeah.
You sound a little bit loud to me. Or not loud. It's like speakery. Is it not loud? Not loud to me. You sound beautiful to me. I'm just saying it's like speakery, but I don't know. Can I do something or is it okay? Am I losing it? I don't even care. I'll just let it be. So anywho, just
use my phone or any of that stuff. I'm just
who am I? Who do I give a shit?
Screaming into my Mac microphone. It will do whatever it does.
You are perfect, and I don't care. I just don't want you to not hear me at all, or I do want you not to hear me.
Very easy to hear, I assure you.
Perfect. So now I just wanted to ask, seriously about today's cross as it related to Hank Brennan getting into the weeds with Rentschler about him never saying that it was at 24 miles per hour and that you don't know what the actual position he was in, and you don't know the speed, the position, the body mechanics. You don't even know where he was on Fairview Road. If you go back and watch the testimony of Judson B. Welcher, only thing he said, right, was that it was consistent with being struck in the being struck, but over 8 miles per hour. And I just wanted to pose back to you. In the event that Officer John O'Keefe was struck at 8 miles per hour, okay, in the arm, which he wasn't, I'm just saying, because it wouldn't have caused the break to the taillight, and he's a moron, keep finger painting. But wouldn't that be, in my opinion, like something he should have been able to do a test? If you did it at 2 miles an hour, I want to see you at 8, mofo. And there's a reason you didn't. That was the only test you did.
You're right. And when you saw the questioning of Brennan, I mean, I talked about this earlier. He knows, morale is a factor. He's losing morale. And when you lose morale, you get more panicky. You can get more desperate, and you can get lazy in your questioning. Not lazy. I mean, he's not lazy. If there's one thing Brennan is not, it's lazy. But his questioning got lazy. And whether he's just not sharp, focused, because again, it's creeping in. You always want to keep that monster out of your head. This is not going well. go away. I can't think like that. And you lose focus, you panic, and you start going after this guy, and you don't realize that all you're doing is essentially outlining for the jury exactly why there's reasonable doubt. No, I don't know these things, and neither does Welcher. And as Rentschler said, nobody knows. That's the problem.
Yeah. Yeah. So if you don't know, then you can't solve for the X. There it is. Period. Point blank.
Yes, but again, Brennan lost the plot on that momentarily, because if we don't know, this is again where the Twitter law school comes in and their lack of education. Given the burden of proof, who gets screwed by that problem? We don't know. The prosecution. Okay, so throwing out hypotheticals, it could be this, it could be that. You're the prosecutor. You're supposed to have a clean, cogent, clear theory. Take the jury by the hand and say, here's how I'm going to prove it.
And this is what happened, and this is the only way it happened, and that's why I've brought this case to you. And Hank Brennan, on so many different, different witnesses, in my opinion, but today was the coup de grace, okay, of hearing him try to word things in a way that Dr. Rentschler would not budge. And it was magnifique, okay, to see him actually say, yeah, you're right. If his finger painting wasn't an exercise in a reenactment of what you were telling us that happened, then what was the point of doing it?
There you go. Full stop.
Thank you, Dr. Rentschler.
Listen, what happened today and yesterday and the several days before that for the prosecution, they're done. I mean, it will take an absolute miracle. And what is he going to say in summation to say, this is the task that Hank Brennan has to win the case, okay? Mm-hmm. Barros is not credible. Loughran is not credible. Squirty Bello is confused and not a big deal. Lopesada is not credible. Russell is not credible. Wolf is not credible. Rentschler, not believable, not credible. None of them are credible. But Judson Welcher and Shannon Burgess, they got it beyond a reasonable doubt. They took Whiffen and Hyde's data and they put it in front of them, and that's it, folks. There's taillight there. It has to be. That's
And that was a very actually interesting place today as well, because it was the first time for me, Mr. Bederow, to hear Hank Brennan, and he says it to every single witness, but for the defense, but saying, like, did you consider the battery temperature of Officer John O'Keefe's cell phone? And I'm like, are you on another planet right now? Who are you lunatic? And I thought it was beautifully put for Dr. Rentschler to say, no, because what I needed to do was check out and to evaluate, analyze, and determine a body and a vehicle, right? The cell phone data, I know you want to pound that into the ground, but it doesn't matter or whatever in the reconstruction of this accident. And that's what they have tried to pull in with Burgess and Judson B. Welcher, which, like, yes, I get that, like, the steps might do something. The steps of the Apple health data, I guess you could equate that may have something that you could use with it, but the friggin' battery, that is where he has really overestimated his experts, in my opinion. We have Shannon Burgess, who is 100% been impeached on his education, training, and experience. And then we had Judson B. Welcher, who was very difficult. He was hard to follow, and he gave a lot of back talk to all of the attorneys, but specifically to Attorney Alessi, who never really got even flustered when we see how Hank Brennan has acted in the defense's case in chief. So, I mean, all in all, Aperture sucks.
Can you imagine you hire Aperture again, second expert, $400,000, whatever.
Woo, clutch of pearls.
But you hire them from your office. They are by definition biased in the sense that they've been hired for this. They change their opinion apparently on their own, all that stuff. There's all kinds of weirdness. There's all kinds of, I mean, look, they are classic hired guns, okay? They are classic personal injury law experts, right? I mean, they are just, you get car accidents, you get whatever, you need an expert, and you go to your little directory, and after you flip through the pages and you skip by Coffin Daffer and the other ones, you come to accident reconstruction, you pick them, okay? And that's what they are. And then you have the people from ARCCA who are like, we're building seats that can help soldiers not die when they hit explosive devices in the desert, okay? We can help save hockey players from getting paralyzed and injuries by doing this. These are real engineers, okay? They get hired by the United States military, the National Hockey League, firms like that.
Yes.
Not always just, prosecutors who put out an RFP for an expert, okay, and get them off the internet or whatever. And knowing that, how ridiculous and petulant does Brennan look going after these guys about, did you take an Uber so you would not appear to look biased?
Oh.
Did you eat
that ham sandwich?
That ham sandwich. And all of this stuff. And you say, they are paying this guy, not to get all Dr. Evil, but $1 million to do this. Okay.
Yeah.
For this.
No, Scott.
On top of all the other expenses and effort they're putting in. And you just look at this and you say, this, and there's no conflict of interest. Allie is sitting there on video yesterday playing with paper clips.
Yes, do you do?
Yes, I did. Somebody said it to me, and I said, this can't be real. This cannot be real. He's literally twiddling paper clips.
Oh.
But the point is, there's no conflict. And this is what the Michael Morrissey DA's office is doing.
Yep.
This is insanity. This is absolutely insane.
Yeah. 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 It's unbelievable. And like we've said this many a time, that, if it wasn't so serious, we would have to laugh and say this is almost comical. It's not, because of the subject matter. But at the end of the day, this is terrifying. And it's terrifying that the Norfolk DA's office, Michael Morrissey, Adam Lally, is now, in my opinion, after talking to you early, like last week, Mr. Bederow, I can no longer sit back and say that I know that you just making the donuts, your culture is toxic. Your culture is criminally, I don't even know. It's criminally adjacent at this point because of what the power and what you have done, and abused it and used your office to prosecute and persecute a woman. And God knows what else, in my opinion, has gone on for cases that are not as high profile as Karen's.
Well, you always think like that. And I've said this many times. I used to say this about a lot of the cases I had that were high profile in Brooklyn, when they had a real Norfolk type problem. Not so much anymore, but you would always say, if they're willing to do this, when they're not under the radar, when the lights are shining and there's media and public interest and this sort of thing, what do you think they're doing when nobody's looking?
Yeah.
I mean, what do you think about the poor guy, from, you know, some poor neighborhood of Manhattan who doesn't have the resources, you know, may not look like you or me, and is getting railroaded and can't fight this, and nobody's paying attention. You don't start doing this on big cases. That's not how it works. You said this a few minutes ago, and you're right on point. The culture is toxic. Okay. Look at the state police unit of the Norfolk DA's office. Okay. They thought these text messages were funny, appropriate, and just business as usual. No women on those exchanges. There's a reason for that, because they know it's how we do it. We'll keep them out of it, but here's how we roll. Here's how we do it. And the whole place, I mean, I used to say this a year ago, the whole Norfolk culture in the office with the state police, it just needs to be fumigated.
Yes.
And the only way to fumigate it is at the ballot box, really.
Yes. Yes. And that needs to be done. And we're, you know, it's coming up. It is coming up. Change is coming. And this feels momentous. I know that you don't like the free KarenRead, the antis. You don't love that like terminology as it relates, just because.
I don't care about the terminology, and I don't care that it exists. I'm just saying I'm a lawyer, not a cheerleader. Do you know what I mean? Like there's
for justice always.
But I mean, I look at it from a lawyer's standpoint. I mean, when I first followed this, if I thought the evidence said that, you know, oh, Karen's got a problem or she's guilty, I would say, listen, you know, it's how I look at it. I didn't sign up in some cause. And I think especially as lawyers, for whatever reason, you know, you get an extra layer of credibility just by default. You know, you need to look at this through a different lens and you know, and whatever. But so when I say the whole movement or this, the only reason I'm not comfortable with that is because as a lawyer, I mean, if you showed me evidence tomorrow that was the other way, you know, conflicts aside and all that, from, you know, representations, I would say, well, you know what? It's not good. You know, like, I have to call it as I see it. And there have been some things been critical of. I mean, I certainly think they're on the right side of this. I mean, I think she's getting railroaded. I think this is a disgrace. I think she never should have been indicted. But, you know, I'll call it like it is, and I would say it. I probably have said it to her, but like, I don't think you should be talking. You know, like, that's not a good idea. And there's other things that have happened, but you just call it like you see it. But that's my only thing about, you know, I don't like to be part of a movement. I'm just a lawyer calling balls and strikes. And yes, I have an opinion. I'm fully aligned on the side that she is 100% not guilty. And I'm very strong in that belief. And if that triggers other people to say, well, you're some kind of grifting hack, that's different. Okay. I'm not a member of a movement. I'm a lawyer who can see what's going on, and she's getting railroaded, and that bothers me.
I love it. I love it. And that's why, let me be perfectly clear. I too, although love the movement, am, when I started looking at this case, and I was like one of the first people that was like talking about it on the TikTok, I remember, and it was a scary time, and it still kind of is, because there is a lot of backlash that we get, and especially if you do have a professional career. But I'm not going to back down. I'm not going to be somebody who is cowering because of my opinion or standing up for what I believe is right. What I believe is right. And I have researched thoroughly. I am not a moron. I am not somebody who is uneducated. I am somebody who has thoroughly reviewed and been able to have an incredible understanding of outside that, what has happened in that courtroom in pre-trial, all the way back dating to January of 2024. You know, so there is so much there. So for anyone that criticizes or says that we are just saying what we say or what my opinion is, it's always been based in a medical principle. And I 100% say all the time, if I think that, like, I'm like, ooh, that's not the best thing that we've seen, but in the sum and substance of everything we've seen in trial 1 and in trial 2, I firmly believe that KarenRead is innocent and should be found not guilty on all charges.
And I mean, I'm assuming if I was some kind of hack and had nothing intelligent to say about any of this, then probably these media people would not call if you're some hack in the tank lawyer who also represents, somebody kind of connected to this and previously was on the cusp of trying this very case. So yeah, I mean, you have to be credible in the analysis, and that's just, I think lawyers in particular, though, are particularly obligated to call it down the middle. And if you can't do that, then you probably should be quiet.
Yeah, agreed. And I remember seeing Jafar, as I call him, Mike Jaffa, when he would get on and him saying that he hates Karen. He'd go on Court TV and
guy. Oh yeah, that guy. Oh.
About, like, I hope she gives herself enough rope that she proverbially hangs herself. After you talking about Proctor, I mean, the crap that man has said on public television. I'm like, how do you have a law license, good sir? But that aside, I'm not saying that everyone is perfect, that it believes in Karen's innocence, and I'm not saying everyone's the devil that believes that Karen is guilty. You can believe what you believe, but you're not going to intimidate, harass, or you shouldn't be out, in my opinion, coming on, like, for people's jobs. Sometimes I think that maybe goes a little bit far, and maybe let's not tell people to end their lives. But when we're going back to, I wanted to discuss with you, because I know you would find this something. Mm-hmm. When Rentschler was going over his studies that he included, we know that the one study that was included by ARCCA of the 1979, which predated the first Jeep Grand Cherokee, in 84, but who is she?
That was very effective in terms of undermining Welcher as essentially a fraud as it relates to this case.
Yes. And then freaking Hank Brennan trying to get Rentschler on a footnote that he was like, I didn't even use it for that. Footnote 24. I was like, I can't. But it was very interesting to me because Dr. Rentschler is so educated as a biomechanical engineer, and he was talking about PIP, the proximal interphalangeal joints, the metacarpal phalangeal joints, and also the mid-metacarpal bones.
You just got all nurse. Wow. Okay.
Oh, you're gonna be. Oh, she's got her composition notebook.
You're talking like nurse language now. Okay.
Well, we're gonna go here because we're gonna have mind-blowing moments. So listen. So it would be on average that it would need 397. The pressure needed to break the bones, or it would be 397 and 361. I want to tell you, at 15 miles per hour, with an exemplar of that was similar in make and model of KarenRead's, it would have been at 15 miles per hour, 483 PSI, or whatever the pressure is, or force needed. At 24 miles per hour, that is 827. That is double the force, Mr. Bederow. And then when you go up to 29 miles per hour, you are looking at 1,482 pounds per pressure. So if you're going to tell me, again, this is facts matter, science, physics. And this is stating, this was right after the x-rays of Officer John O'Keefe of his right upper extremity were placed on that screen for the jury to see. And I tell you, for me, that was monumental. This is
Uh-oh.
No.
Oh.
Oh, Mr. Bederow, can you see me?
Now I can. You froze up.
Oh my God.
I can switch to a hotspot. Give me a minute, all right? You may lose me for a second. Hold on. There you go. I'm back. Nope. Nope.
Can you see
there
me?
I am. Yeah, you're frozen, but I can see. Yeah, I switched to a hotspot. We're good.
Oh my gosh, I am blacked out right now. I'm gonna cry. Are you good?
In through your nose, out through your mouth.
Yeah, I can't have tech issues when you're here. This is panic mode.
No, we're good.
Okay. We're good. Okay. All right. I am here. You are here. We are here. Okay. Look at everyone knows. They're like, gosh, Kim. All right. She's frozen. I should be back. Everybody, are you back? I'm back. Oh, we lost Kim. She's frozen. He's frozen. Are we all here? We lost Kim. Here. Okay. We're here.
Cool. We're here. We're here. Go.
All right. We are all together again. So all I was saying was that with that specific study, it was more than evidence for me. Anyone that I believe, any women in STEM on that jury, that was so clear after you are showing the imaging, right? You showed the images that say there are no breaks, there are no fractures, there is no even swelling or bruising. That's a wrap for me.
I mean, I said this last week, I think to you, I think a 10-year-old watches the 24-mile-an-hour video, sees the evidence, hears what the doctors say, and just from your own experience, I mean, if you've ever broken bones or had fractures or whatever, that an arm dangling out, getting smashed at that level of force, at a minimum, you're going to get a really big owie in the form of a nasty bruise.
Yes.
Never mind a possible fracture. And to literally have nothing, the hoodie is intact, at least, you know, based on the test samples that they did. Where are they going here? They're going nowhere. They're going down the drain.
And fast.
I mean, it's kind of ironic because the word, you know, I know the word that Brennan likes to use is, you know, inevitably. It's inevitable within a week or so that this is going to be over and she's going to walk out of there.
Oh, Mr. Bederow, that makes me so... Just hearing it from you, it does have different impact than from... And I know that I think I have pretty good...
Well, you need to hear it from jurors, not me, but yeah.
Well, no, but you know what I'm saying? Like the breakdown of it and the analytical, the ability for you to say, bar a miracle for the Commonwealth of some random, I don't even know what.
If this was a boxing match or an MMA fight or whatever, they'd be tapping out or throwing in the towel. This is that bad. And the other problem that they have is, so now you're going to get, you know, obviously the defense is in a position of strength. And all they need to do is drive it home and impress the jury with what matters and with the passion of what it entails and how important this is. And who would you rather have making that argument? Hank Brennan or Alan Jackson?
Alan Jackson.
I mean, Brennan is going to go on and talk about, you know, she said I hit him and these clips and this and how unreliable these defense witnesses are. I mean, this is an opportunity for someone like Alan, who is just an incredible communicator.
Yes.
As a lawyer, just an incredible advocate, incredible orator to give. I mean, he's on the cusp of the moment that every trial lawyer lives for, which is the chance to sum up in a case like this when they can taste it. Okay. I mean, this has been 3 years of hell that they've been going through, and they're literally, you know, they're at the goal line and they just have to punch it in. And who better to do that than him, and grab the attention of the jury and make them not only just focus on evidence, but make them feel obligated and compelled to stop an injustice and put it to bed. I mean, that's really the goal of a summation in a case like this from somebody like that. It's not just to literally say there's reasonable doubt. You have to do all of that stuff, but make the jury go in there and want to run through a wall to do the right thing.
Yes. Yeah. And I think that they will, especially with them being so young too, Mr. Bederow. That is something that I do want to say. I believe in my heart of hearts that the young boy in that I saw, I always joke that he could be my child. I could have birthed him. You know that this poor kid just graduated high school or is like, 18, 19, whatever. He's on his break year. He took a year off for travel. And we know, I like to say he's going to Europe and backpack after he's done with this. But he, like, him seeing this firsthand and him not having exposure or anything else that he has witnessed, and seeing him perk up when I was at court and really like locking in when AJ was speaking, because AJ was the one who was cross-examining Gallagher. It was so honest and it's real. And this group of individuals, there's 18 of them, and they are, I know that we can't talk about them and I don't know them at all. I only saw them twice, but they are like, they skew younger. They are of a diverse ethnicity groups, and they've given themselves almost eight full weeks here. You have given of your service. At the end, it's gotten hairy. There's been times that it's been almost a whole day that you guys are out of the room because there is so much fuckery afoot in the Commonwealth of Massachusetts. And Judge Cannoni had to kind of send them out. But at the end of this, I think that their impact, and the jury is the only one that matters, but their impact and their age, I think, will play to, freeing KarenRead, because they know that you can have issues with government, unlike when I was a kid or when my grandparents would have believed anything that any police officer said about my parents when they were young.
Yeah, I mean, you can be 1,000% supportive of good law enforcement and say that the law enforcement in this case is a fucking disgrace.
Mm-hmm.
That's okay. And frankly, it is. So, you should feel that way. You should be generally supportive of law enforcement, but not the kind of shenanigans that went on here. And that goes right down from the prosecutor to the state police, to the Canton police, to, the witness from last week who came in with that attitude. I mean, everything about the law enforcement involved in this case has just been gross.
Yeah. Do you think they're going to give the witness instruction, the missing witness? Do you think she'll give it? Thoughts?
I mean, look, in that courtroom, the biggest criticism you have, I mean, we'll find out tomorrow, obviously, but she is so unpredictable. There's no consistency. All the dots are checked off for granting the instruction. Although it is true the defense could have called all of them, that's true. They're not unavailable in that sense. But because they are so expected to give testimony favorable to the prosecution, and you know that because you have a record. You got to argue this tomorrow. You have transcripts. They're under oath. You know what they would say in theory.
Yeah.
You know that they are 1,000% pro-prosecution. So why should we have to call them for the purpose of antagonistic testimony, right?
Yeah.
So the answer is she should give it. If she doesn't, all it means is you're not going to get the adverse inference in the instructions. The defense is still going to argue they didn't even call these people. They didn't do this. Now Brennan can say, well, neither did you, but you don't get the adverse inference. You're still going to argue.
Hi, Winnie Lola.
Yeah, that one's, I don't know who that was. I wasn't paying attention. But they're still going to argue, how could they keep Proctor from you? I mean, how could these people keep Proctor from you? Okay. They try to tell you that there are holes in the back of a hoodie that they know or should know did not come from this incident, and try to tell you they did, but they won't give you the lead investigator.
Oh.
yeah, you can do this. You can attack the integrity. There's evidence to suggest that the prosecution has been sneaky. That's fair game. Now, not everybody is willing to do that. I get it. But if they want to point the finger and say that they intentionally tried to mislead you, they can do it. There's plenty of evidence.
Now, what do we feel like? Because I was shocked, Mr. Bederow, when Judge Cannoni didn't address the weak instruction from the actual holes, right? Like, what? We're just waiting now till it's the jury instruction. That's it. But isn't it supposed to be done like right near when the event happened to cure the jury or whatever?
In a perfect world, they would have gotten the instruction then, and then the defense would have asked for you to give it again during jury instructions, which I'm sure they will. That'll be fixed tomorrow. But yeah, I want it right away, and I want it in the main jury instructions.
Oh, I love that. I like that more, actually. So I'll shut up because
they need a better instruction. And, look, they obviously submitted an application basically saying that they deliberately tried to mislead the jury. She's never going to do that. What she ought to do is say that the prosecution, implied this, and it's up to the jury to determine what it means. But it is fair game to argue that that was an intention to mislead.
Okay, with that being said, if you were going to say in summation, right, talking about, just because we're on the thought process now of the prosecutorial, just saying that maybe they've misled you here and here and here. How about with Hank Brennan and his harping on saying that ARCCA was using the 50% 50% ATD dummy, and then to find out during the Rentschler testimony that, and also through Dr. Wolf, but more specifically with Rentschler, talking about how Welcher used the exact same dummy for the head test on a concrete floor.
They should point it out and say, again, they're not trying to fool me.
Yeah.
They're trying to fool you, the jury. Okay. There was all this righteous indignation in cross-examination that Dr. Wolf was trying to snooker and rig the results by using whatever the name of it was, the 50% dummy. Let's just call it that.
Yes.
I don't even remember the name. And it turns out
hybrid.
Welcher used the same one. And oh, by the way, the whole purpose of Wolf using a dummy and doing his test was to critique and emulate and prove wrong Welcher's work. So better you use the exact same thing that he did. We're trying to show you why he's wrong.
Yeah.
And yet they should pound all this repeatedly. And look, they laid the foundation today. As I said, he got up today. I'm mad as hell. We're not going to take it anymore. Do it again. Go after them. Not personally, not because Brennan is an unlikable person, not because he's a bully in the way he treats witnesses. You go after him because there's a credible argument to make that he was trying to intentionally mislead jurors related to the hoodie, related to the crash test dummies, related to the x-rays, which may or may not have been shown. It's either him or the witness. You go after him, you pound him, and make him waste time in his summation, either ignoring it or wasting valuable time saying, that's not true, and they're just saying things and whatever. Look, he's a part of this. Okay? Yeah. The stunt you saw with the hoodie, I don't know how any reasonable person could think that was not intentional. Okay? These are experienced lawyers that have been doing this a long time. They know the case in and out. They waited to the very end of the cross and pounced with this gotcha moment. And if you think that there's any way that somebody as deep in the weeds of this case as Hank Brennan did not know that one of the biggest pieces of evidence in the whole case, the hoodie, the hoodie is huge. It's been huge for 3 years. He didn't know about the back of the hoodie being done by his criminalists in 2023.
Mm.
If he didn't know, he should have known. And if he
Right.
still didn't know and he should have known, he should have asked Lally, who knew or should have known. And if the two of them didn't know or should have known, then they should have asked McLaughlin, who should have known.
And she knew.
Okay, this is a disgrace. The evidence clearly suggests they knew. The jury has that evidence. They should punch them in the mouth with this. And again, you need to wear the white hat as the prosecutor. You need to be the credible one in the case. And that's not Brennan.
Yeah. And I think that it was 110% obvious and very apparent to the jury today. I mean, crystal freaking clear. When I saw the video of that vehicle going back at 29 miles per hour and just going and I said, I mean, like seeing Randy, I go, oh, like I mean, the way he he flew, you know, I go, oh, Randy, I was said, oh, honey. So it was apparent, right? And you are seeing that. And then for Dr. Rentschler to give us the opinion that, okay, if that was a straight on hit, you are going with the car. There was no, Randy didn't, fucking bang a right, no offense, but it doesn't happen that way.
It's called physics. And physics is a hard science. This is not open for debate. And this is another example of science in general and hard science, particularly, why this case is so fundamentally flawed. I mean, I go back to this all the time, and for the life of me, don't understand when the feds dumped all those materials on the parties a year and a half or whatever it was ago, and they saw what the ARCCA conclusions were. For the life of me, I can't figure out how you can be a serious prosecutor and not call a timeout and say, we need to reevaluate our lives here and what we're doing. I didn't say dismiss the case and run in there, but take a timeout and say, this is troubling. Maybe we're wrong. Maybe we're doing her dirty. Maybe there isn't probable cause, let alone proof beyond a reasonable doubt. What do we? And all they did was charge ahead. Nothing to see here. Let's go. And that's disgraceful. And now you're seeing the consequences of that action. It didn't happen a year ago, but there's a really big difference between last year and this year.
Oh,
last year, the ARCCA witnesses were thrown on them, but they weren't even allowed to talk to them.
Yes.
Now look at the difference when they're allowed to actually talk to them, prep them, show them reports, and do it that way. Not that they were bad witnesses last year. They weren't, of course.
No.
I mean, the facts are what the facts are. But how much more compelling were they this year?
Unbelievable.
They were so compelling that they literally had Welcher disappear from the case.
Well,
he's supposed to be there tomorrow.
You put him away. All right. You put Welcher and locked him up in an attic. I don't know, somewhere.
Well, maybe he's on the moon. Anything is possible.
Oh. Well, it could be. And it was at that moment that I too realized that if there was a glancing blow, right? Now that was when we saw Randy, justice for Randy, okay, like stand with Randy. He was going, if it was 10 to 12 feet, 7 to 10 to 12 feet perpendicular, it's not possible to occur. And that is where the rubber meets the proverbial road. And your opinions were bullshit. No offense, Aperture. Like you got paid so much money and exorbitant. And I know that it might not be a lot to you, but to regular people, Mr. Bederow, like me and those jurors, that's a lot of money. And then when you were looking, and we know that although Dr. Rentschler did not give us a number, he's like, hey, babe, I just get my regular paycheck. But Dr. Wolf said, I think that they've been billed around 50,000, so on and so forth. Well, I can get behind that for what the frig you've done. I saw all your experiments. I saw your incredible reports, your slideshows, you having the arm that shows that those injuries and the tail light, if it did happen, would have had to go in one direction. It's not plausible that it would have been going, in all the directions that you're stating because of what? Physics. Everything would have been thrown in that direction. And it's just, to me, it was that nail in the coffin to hear it and have it be wrapped up in a bow. And it was incredible, like literally incredible today.
Well, the problem with the prosecution is, I mean, I could think of 30 different stories where you could say that's the nail in the coffin. I mean, at some point, the coffin is slammed shut and there's no way out. There's just so many problems. I mean, they're just smothered by the reasonable doubt. There are so many things that they need to convince the jury are not worthy of belief and are not reasonable. And it's just impossible. And you know what? There may be a few facts that they did better than you would have thought in the beginning of the trial. So, for example, by not calling Richard Green, maybe the jury is willing to say, I don't really care about the Google search. At this point, and by the way, at this point, I would assume the jury would say, I'm not even like addressing that. It doesn't even matter at this point.
Yeah.
I'm not suggesting it's overwhelming, but it's taken a back seat. It really doesn't matter. I mean, what the defense has done a really good job this case is driving the narrative in the last several weeks, or last several days, I should say, which is that the science is unequivocally on our side.
Yes.
Okay. And that's the takeaway. And by Brennan not doing a rebuttal case for whatever reason, whether to save his own rear end or just because he knows his witnesses are going to get destroyed, he yields, again, primacy and recency. He yields to Dr. Rentschler the last word, and even going back to Lopasada and Wolf and all you always want to finish strong.
Yes.
And the prosecution finished in a whimper. I mean, they have done nothing good in weeks. I don't know if they've done a lot good this case, but all of a sudden those clips almost seem silly.
Yeah.
Okay. If he's going to come into summation and say, cue up the clips of Karen, I did this and I did that, as opposed to explaining to the jury why all these defense experts are not credible and believable and the other witnesses, you might as well just quit and go home and not even show up. I mean, you can't argue the guilt based on the clips and Burgess's text stream analysis and not dismantle everything else that the defense has put out there. It's too big a burden. I don't know how they're going to get past it. It's too great.
And speaking of that too, Mr. Bederow, I'm wondering when, for him not to bring, for Hank not to bring back Welcher at all, right? That is conceding, in my opinion, because you have nothing else, there is nothing left to say. I felt as though yesterday, now forgive me if I'm a little fresh here, but I think that Dr. Lapasada broke Hank's spirit, because I'm telling you, he got a little bit with everyone, even Dr. Wolf, and he didn't get much. I'm not saying much, but I'm just saying, I could see a little bit. I could see a little deflate. And you know me, I'm an empathetic person, and I'm like, oh, babe, you know this. You're so smart. Don't let him fuck you.
She pantsed him is the word I used to Grace Curley. She just completely pantsed him. And so did Dr. Rentschler. But
yes.
Does that mean he's quitting? Maybe. In terms of, I can't even call Welcher anymore. I'm not fully ready to believe that his decision not to call Hartnett and Welcher, I'm not so sure that does not to his own self-interest, okay? Because both of them could get hit about the issues which he appears to have engaged, or at least there's some evidence to suggest that he has engaged in some dirty pool and shenanigans as it relates to the hoodie. And maybe he didn't. Maybe he has a perfect, innocent explanation, but I think there's a lot of evidence to the contrary of that.
Yeah.
The hoodie and the x-rays. This witness said, I looked at x-rays, but not those. So I'm not so sure. It's just, I know they're not going to be effective anyway. And at this point, the goal of the exercise has changed for me. It's about self-preservation. And I'm already in trouble here. I mean, this case is going to follow him around.
Yeah.
You know, you took this for whatever reason. You gave all the speeches about your only concern is making sure she gets a fair trial. You've engaged in behavior that would suggest you're interested in anything but that.
Yep.
Okay. And now the check is due, right? You know, the time is up for the jury, and you've put on an atrocious case. You've potentially subjected yourself to some serious ethical criticism about what you've done. Maybe you just don't want that to come out. I don't know. Either way, not having a rebuttal case is really weak. It's not because he doesn't think he needs it. Let's all agree. It's not because I'm winning. Okay. Welcher should be testifying to contradict that. Okay. Hartnett should be testifying along with Kuhn or whoever to kind of dilute the dog bite thing.
Well, but you can't. She did it wrong.
Right. Well, but he said he was going to call them for some other reason, something about it. The point is, at this point, he's not even really challenging the dog bite evidence other than his own cross-examination saying, I don't believe it. I don't believe it. But he has no evidence from any medical person to say that I can eliminate dog bites or scratches as the cause of this. To the contrary, Russell says, I believe it is.
Yep.
Scortibello says, I can't eliminate it.
Correct.
And Lopesada says they're consistent with animals, not dogs, only because the judge, in a frankly ridiculous ruling, split the baby and said, well, you made such a good argument, I'm going to let you say animal instead of dog, which is makes no sense. But nevertheless, it helps the defense to some extent.
Mm-hmm. Yeah. And so they never called Crosby. Remember, we heard about, we were going to hear all about Crosby. And then I do want to just bring one other. Remember that motion for the ring, right? Like they had subpoenaed Ring so that they could have someone from that company come and kind of have I lost Mr. Bederow now? Oh, what am I doing? Oh, I see you. I see you. You were gone. You were coughing, Lovey. Is it me? Am I
no,
the problem?
No. I'm like this lingering cough and all this talking. It's okay.
Oh, okay. Well, I'm just making sure you
cough drops as basically for nutrition at this point.
Oh, okay. Well, there we go. I keep grinding up and getting them right in there, and just allow yourself to have. I want you to gargle at night. That'll be good for you. If you do a little salt water gargle, very good for the throat. Just saying. Cherry
Halls, which by the way is an old litigator's trick. Never go to court if you're going to be arguing without Cherry Halls. It strengthens the voice.
Oh,
I've been doing that since law school. Somebody told me that. It's probably a bunch of bullshit, but it's become like one of those things that you just have to do it.
Oh, okay. Well, I'm going to start having them in my pocket.
Cherry Halls. Anyway, the ring video. What?
Yeah, just the Ring people. I wanted to know, where were they? Because every big mouth, internet, Twitter, frickin', lawyer said from that motion, they were like, you're an idiot, Kim. And I was like, bring it. Because KarenRead never had access to Officer John O'Keefe's Ring system, right? He had it on his phone. It was never found in any of the computer, the desktop or the laptop upstairs. So shut the fudge up. And the other thing was that if there was, by any chance, because the prosecution talked a lot of shit about there being video gone, even unfortunately, Mrs. O'Keefe believed that that we should have never let her go upstairs, inferring that that a video was deleted there. But here was the thing. If any Ring video was deleted, then it was deleted by Mass State Police because they had custody of it and were still receiving, per testimony of Jessica Hyde, there was still, those Ring notifications coming through till at least noontime on January 29th, 2022 on Officer John O'Keefe's phone because it had never gone in a Faraday bag.
It's true. And there are so many of these facts, but all of these facts are probably going to get kind of pushed to the side.
Yeah, they're not important.
No, they have nuclear issues, right? All of the scientists and all of these things. These are big game issues. You can weave in some of the small stuff, and if they have the time, nobody will do it better than someone like Alan will. But
yes.
You got to go big, and the reality is, if I'm doing a summation in this case, honestly, 85% of it is going to be science. I mean, I made the joke. I think
love that
probably to Mike the other night. I mean, I'm quoting Jesse Pinkman, right? Science, Mr. White. Yeah, this is all science. The science is literally 100% on their side. I mean, look at all of the medical and PhD engineering, putting aside Welcher. I mean, whatever, putting him aside. But look at all of the medical witnesses. They are all essentially defense witnesses. Their own medical examiner told them, I don't know the manner of death. That may be a good place to actually start, literally out of the gate, and say, from the beginning, this case has been awful. And the first red flag was their own medical examiner said no, after being told, oh, we think she hit him with a car. She said she hit him. There's glass. And she said, that's great. I don't know.
Yeah.
And you go from there. I mean, it's everywhere.
Now, how long are they usually? How long because for a case of 8 weeks of magnitude, summations, how long is it typical for an 8-week case that you would have in New York?
Well, normally, and by the way, when I'm citing New York as the voice of reason, that's scary. But I mean, as compared to Massachusetts, I'm fully satisfied that the New York criminal justice system is a little more normal, to be honest. Normally, judges will ask you, and by the way, in a very casual way, most trials that I've been a part of, not all, I mean, there are most of them, though, are at least between the lawyers, not always the lawyer to lawyer, but with the judge, the court is very engaging off the record and just will say, what are we doing? And tell me about the case. And not everything is done by motion, right? You don't need, I mean, I honestly feel like if I had to go to the bathroom, you'd have to file a motion to, file it in writing for permission to pee a week from now during summation.
Correct.
All that stuff aside, what in my experience, what judges do, you'll get asked, I'm not holding you to this, but how long do you think your summation will be? So suppose the prosecutor says, an hour, hour and a half. Okay, what about you? And you say, the same. And the judge will say, all right, whatever. There's no stopwatch. There's no time limit. You're not, I mean, in the first trial, you literally had the judge interrupting
Adam Lally.
You have 2 minutes, 1 minute. And if you watch Lally's, I mean, it has nothing to do with what side you're on. I thought it was just wrong in general. She basically said, you're done. And he's like, can I finish one sentence? I mean, what a horrible way to end a murder case where you're getting shut down. So there's no stopwatches. No one's shutting you down. There are times where limits could be imposed, but not an hour. Now, in the normal case, if you're going on for 2 hours or 2.5 hours, that's too long. This case is a little different. So if they can do it in an hour, I think that's a good goal. But if they sketch it out and it comes to an hour and 15 minutes, who gives a shit?
Yeah.
Do it. Just let them do it. Whether it's Brennan or Alan, let them do it. Let them say what they need to say. The jury's not going to complain. Just do it. Let them argue the case. I mean, I know in New York, like in the Trump case that they had last year, there were no time limits. Now, having said that, they gave summations that were like 4.5 or 5 hours, broken up with breaks. That was a very different kind of case, obviously, but that's too long. But nobody said we're not allowing that. You know, the judges generally will let the lawyers try the case.
Okay, well, that's really good to know because I don't recall, like, I don't ever recall knowing this much about a case that I've covered or I've watched, but I've never heard it in open court, just like discussed, or that I saw when I was covering it. So that to me, I always just wanted to know because someone else had said, or not, it was actually in a paper that they got 2 hours for Hank Brennan when he did the Whitey Bulger case in like 2013, I believe. And that was
federal court. That's what it's
federal
different.
court.
Federal court is much stricter, and federal court also has the prosecution goes first, the defense goes second, and then they get rebuttal, and the prosecution I mean, so it's a whole different system. I mean, I think you'll find out tomorrow how long they get. Probably she's going to say an hour, and probably her logic is going to be, whether you agree or disagree, that the trial, in essence, is roughly around the same time as long as it was last time.
Yes.
So she'll just say that worked, so we'll do it again. That's my prediction.
Oh my. Well, that is typical of her. And I just think that it is, at this point, it has been a showing that, and maybe she's exhausted. I know she keeps bringing it back to the jury and saying that the jury is checking out.
They're telling us that I didn't see this because I shut it off when it was over and I missed the colloquy at the end. But they're telling me that she said an hour and 15 minutes.
Oh.
To be honest, I have to be honest. I find that petty. I mean, to say I'm going to give you 15 minutes, but this far, but no farther. I think you ask the lawyers; they're professionals. How long do you think you're going to be? And suppose a lawyer says, "Judge, I think it's going to be an hour, no more than an hour and a half, an hour 20 minutes." I think at that point the judge should say, "That's fine," and just let it go. And if one is longer than the other, it is what it is. I don't think you have to put rules about everything they do. Let them try the case.
Also, sidebar, how awesome has it been the last couple of days seeing actual speaking objections?
It has been coming out. Yeah, it's true. It's been slipping out on both sides a little bit more. The frustration has been setting in, but that's also part of an example where you see there's no knowledge, there's no consistency. The lawyers don't know what they're going to get, and if you don't know, it becomes more frustrating. Okay, I mean, it's very similar to like professional sports. If you have a hard judge who runs a tight ship, and that might influence what you do or what you expect. The problem with this case is it is like a box of chocolates. You never know what you're going to get when there's an objection, and ask it different, and then the lawyer will ask it different. But to be candid, it's objectionable for the exact same reason. It doesn't cure the problem, and she'll say, "I'll allow it," and there's just no. It feels like a free for all with the objections. It just does.
Yeah, and when she is saying it's interesting because after the blow up this morning, right? Like at the end of that line of questioning where absolutely AJ said, I've had enough, I won't take any more, right? Or whatever the saying was.
Bad as hell, and I'm not going to take it anymore. Network.
Yes. As soon as he said that, she had them leave for lunch. She doesn't even like address. And I said, this has been for me, and I don't know, how the jury, because if they're not going to be there, but she's taking these lunch breaks. She's saying, you can go. This is a great time for us to stop as soon as everyone is starting to cook, and we're doing these kind of just underhanded slights that I am seeing. And I'm like, oh, for frig's sake, this wouldn't be happening if it was in regards to the Commonwealth, in my opinion.
Most judges, when it gets snivelly like that, would tell the lawyer, instead of just saying sustained, they would say, enough. Don't do it again. And they might even call them up and just say, listen, cut the shit. Because the next time I say it, I'm going to say it in front of the jury and like that sort of thing. I mean, unfortunately, it doesn't appear to be even-handed in terms of admonishing in front of the jury. I mean, it's just the reality. I mean, I think the best example you saw of it, and the most striking example, because it was the most you've got to be kidding me example, was as involved the mistrial application the other day. Most judges would look at Brennan in those circumstances, outside the presence of the jury, of course, and say, what is happening here?
Yes.
And explain to me. Don't just say it was a mistake, because I'm entertaining a mistrial application. And what's very relevant to that determination is whether I think you did this on purpose. That impacts my judgment of my remedy for what you did. And no concerns at all. And as they're sorting this out, she, was yelling at the defense lawyers for having the temerity to talk. And she said, okay, you don't want to listen to me? Fine. We'll just bring in the jury. I'll do it my way. Forget it. That was so bizarre.
Yes.
So disproportionate in terms of what should upset you right now. And just so bizarre. There was just no place for that.
Yeah. Yeah, that threw me for a loop. And I was like, oh, I got so nervous. And then you know that everything in Alan Jackson was like, fuck you. Or not like that, but he was like, for him to apologize, just from the frustration of like, hey, super sorry. I just need a minute to make sure that this is going to work for what we believe is a big deal. And she's downplaying it. She's saying time management. She's spitballing it, Mr. Bederow, from the freaking bench, and saying the wrong date while she is spitballing this and saying, oh yeah, well, I'll say it's this one, in 2025. I'm like, no, don't say that. Take a moment. I thought she'd retire to her chambers, but she didn't. And it was very concerning to me watching it. Never mind AJ there just trying to get one sentence in, and then they had to apologize. And it's like, what are you apologizing for? This is her friggin' job.
That was a terrible look, but unfortunately part and parcel why so many people have no confidence that this case is going to be tried properly. They have no confidence in how the criminal justice system down there works. And you see that kind of thing happening. It's just another example that there is, at a minimum, it's an appearance of bias. I mean, even if she's not meaning to do it, you have to be even-handed in your demeanor and the way you treat the lawyers. And look, she's crapped all over these lawyers again and again. She's attacked their integrity. She's publicly lambasted them in a way which I think is just so unfair, over nothing, essentially. But every time Brennan gets caught with his hand in the cookie jar, or at least ought to explain why his hand appears to be in the cookie jar, crickets.
Yeah. Yeah. And it's just definitely difficult to watch at this point, and we're very aware of it. We've seen it now, not for only one trial, but two, and in my opinion, it has been exponentially. I mean, yes, she helped and she held the hand of Adam Lally. Would you like to object here? I recall vividly, during trial one, But at this point, it is just you. Even when she says, "Just ask a question, Mr. Brennan," no comments, which is very rare. But if she does say it, he's just still going to do it. And she's never going to hold his feet to the fire. We've seen 31 full days. This is the end of testimony. Tomorrow, everyone will do our jury deliberation slips and then, or whatever. Yeah. Tomorrow's jury deliberation slips. Right. And then we do
all that
closing.
stuff. Yeah.
Yeah.
But the closing will be the next day.
Yeah. Friday.
It's not 31 days. It's like 7 or 8 months. It's all the pretrial stuff too.
Yeah.
It's just different because it's at trial, but it's not a good look. I mean, I think if you watch it, it's hard not to see what appears to be disproportionate treatment.
And you know what I was wondering is like, is there no judges, like, don't judges have other judge friends? Like, I feel as though if I was being a walking bitch, and I mean that with all due respect, but if I was like doing things that I was like, hey, this is like unfair treatment of a patient, and this is not even any way relatable, so don't make it weird, guys, sorry. But if I was a judge, I would want someone to say to me, hey, Kimberly Jean, get your head out of your ass. Somebody that I respected, somebody that I was like, I don't know, just a judge friend from the circuit. Like, they don't call each other and say, you look ridiculous. Fix it.
No, not like that. I mean,
no.
Are they friendly, collegial? Of course. But are they going to say, pull your head out of your ass? You look like a fool? No.
All right.
If somebody asked, what do you think of this? Maybe they chit chat. But if anything, the idle chit chat is like, how's it going? Like, wow, that's quite a Megillah you have there, that kind of thing. But I don't think a judge is going to sua sponte on their own initiative. That means call her and just say, look, you got to stop this. I just don't see it. No.
Yeah. I mean, I was just thinking, like, is there somebody that's seeing it and going like, oh, this isn't a good look? And out of care, right? Like, out of care for her of like, babe, you've been doing this for umpteen years. You are able to, you've got an award. She's a former prosecutor. She's a legacy. And it's like, this is what
she's legal aid. She's actually legal aid, not a prosecutor.
Yes.
Or not legal aid is a New York term, a public defender,
public defender. Public pretender. Never mind. Stop it. Okay. So, all right. Well, that makes sense. And there are just things that you wouldn't do in a professional manner that doesn't make sense. She is the end all be all of her courtroom until it were to go to appellate. However, quick question. Today, do you believe, there were a couple of you law tubers that said that today crossed lines in the questioning, and specifically with the previous question we had up about when Hank Brennan brought up planting evidence? When Rentschler said, well, okay, how did it get there? Did somebody put it there versus it happening organically? And out of the mouth of Hank Brennan, first of his name, came planted. What do you think about that?
Well, first of all, I'm curious, what law tubers were concerned about how that played out?
I think it was Peter.
Okay. What didn't you see happen during that exchange?
Objection.
Exactly.
Okay.
Why would you object when Brennan is basically leaning in, pointing at his chin, closing his eyes, and saying to Dr. Rentschler, go ahead, hit me? That whole line of questioning, all it did was invite, not for him to say, I don't know, but how many times did he say, look, I don't think there was an accident. This doesn't make sense. The fact that he's using the word planting, all he's doing is putting thoughts in the heads of the jury at a time when Dr. Rentschler is saying, essentially, there is no car accident. So, no, I'm not faulting the judge. She let it in. She didn't do anything on her own. And Alan did the right thing. He didn't object.
Let it ride.
Sat back in his chair and said, "Go ahead, idiot. Do it," as they say.
Mm-hmm.
I thought it was great for the defense. Why would you even pretend? No, Brennan can use tone and make it sound like it's so ridiculous. But you know what the problem is? It's not ridiculous after witnesses and Barrows. It's not ridiculous. To me, that was another example of Brennan's what I call disheartened, seeing the big picture, and lazy questioning. Okay, that was lazy questioning.
Yes.
So I don't know why. I mean, obviously, I like Peter a lot. I don't know why he would think though that would be, the judge should never have allowed that. I would, if the judge started saying something, I would say, no, judge, no objection. Let him answer. No objection.
Yeah, and his other concern was, which this actually is very concerning. I think maybe you tell me, but the fact that she let him question about his employer, meaning Brennan's asking Rentschler about an employer giving him information during the first trial, and his employer was not ARCCA. His employer was not the defense team. We know his employer was the FBI. And why Judge Cannoni allowed him to tip his little tippy toes in that pool, babe, was very questionable, right?
Very. That was regrettable. First of all, the jury is being led to speculate, okay? Because, is it the defense? Is it this mystery agency? But the reality is his employer is ARCCA, all right? And Brennan, an experienced lawyer, again, he's being sleazy, okay? He's being underhanded. He knows that the hiring party, in this case, the U.S. Justice Department, is a client, not an employer. It's actually, he has it all, they are they were engaged by the Justice Department, okay? The Justice Department is paying them, okay? Who is the client and who is the one being serviced in that relationship? So to suggest that just now, because it's the U.S. Justice Department and they're running a parallel investigation of the DA's office, as it turned out, or people involved, yes, they were talking to them about what was going on. But that was another example of Brennan deliberately and sleazily misleading the jury. And even when they went up to the bench, obviously for Alan to complain about it, she obviously did nothing about it because he came back and started with employer again. Now, the other thing is this. Amongst everything else that's already happened in this trial, that absolutely should have opened the door to the FBI because the only reason my client, the Justice Department, not the FBI, the Justice Department is the weak. Everyone says FBI. It's really, if anybody, the U.S. Attorney, not the FBI.
Yes.
The Justice Department would cover them both. The point is,
umbrella.
If you're being told things by your employer and they're really your client, there ought to be context to what they're telling you, and that you're being restricted from doing anything specifically because your client, the Justice Department, has engaged you on a sensitive and confidential federal investigation into witnesses and entities in this frivolous prosecution that's being tried right now. And if you don't want to get into all that crap, you shouldn't be talking about your employer. That was underhanded and sleazy.
And even with that underhanded, sleazy maneuver, you're putting it's super unfair, and that's the biggest point of it, right?
That's why it's sleazy. Yeah, I mean it's
no, but it's sleazy, but you're using it as a sword and a shield because you can say the shit, but then the shit can't come back to bite you in the ass, right?
Well, yeah, but it's worse than that. You're doing it to mislead the jury on where you're coming from and what kind of shenanigans the witness is allegedly engaged in. And he's saying, look, I have no control. If they tell me things, they tell me things, but it still doesn't affect my opinion. I mean, he handled it perfectly.
He really did. He really did. Great answer.
He was asked, 20 times, and he likes to just keep asking.
I know. I don't get him. I don't get him because he was digging. Today, I was like, please stop, please for you. He's like a dog. He's like, what do you remember that dog? I don't even think of his name right now, but he was a little white puppy and he would always look for a bone in the backyard. Do you remember him?
Benji?
No. Oh gosh, I'll think of it. We're in different ones. Someone's going to fight. Not Fido. Oh my gosh, why am I not? All right, I can't think of it right now.
From a movie?
He was like the little white and he had white spots and he'd be putting the bone in the backyard. Wishbone. You don't remember Wishbone?
The way my next guest was going to be like Spuds McKenzie or somebody like.
Oh gosh. Okay, here we go. So, but all in all, long and short, we didn't get to open the door. We didn't get to open the door for the DOJ or to say the entity, but
the door was already open from the last couple of weeks, but that's another issue.
But she didn't let us walk through the door.
No, but McCabe, Dever, the FBI, Justice Department door, that door was wide open.
Do you think that by saying, for AJ to go up and say the clarification and saying entity, because I liked that, or what did he say specifically? Because it was
agency.
I like that because the law enforcement agency.
Yeah. No, agency means government.
Okay, good. Because I was like, I hope they get it. I hope they're picking up what they're putting down. And like, again, this is a jury. We don't know what it was 18 right now. It'll be whittled down to the 12. We don't know what are their big points, right? Maybe hopefully someday we could find out, hey, what did you guys consider? But this has been such a different case than the first trial. This has been an incredible job, in my opinion, by the defense team, by taking reasonable doubt by the entire balls and just running with that. We do not need to, it may have gotten lost in the sauce a little bit with so many players and so much information that any jury would have a hard time to get to where they were maybe able to go, what we heard from Ronnie, from Mr. Bowties from last year. But this year, I want to talk about the bombshells that we have had in testimony, finding out about Jennifer McCabe's FBI conversations, knowing that we have, Lucky sticking to his guns, having Bederow say in a watershed moment that absolutely not, that taillight was not in the condition in the Sally Port that was the photo that was taken days later on February 1st, 2022. And then wrapping it up in the bow of science that Officer John O'Keefe was not struck by a Lexus vehicle at any point in any way, shape, or form ends the case, in my opinion.
I like the bullet points you made, but I'm flipping it 180 degrees.
Okay.
You start with the science.
Yes. Okay.
Number one, because it's just the most compelling. And then number two, when you have the jury buying into that, all of a sudden Barrows and the taillight makes a hell of a lot more sense because it has to be. And then you work in the Proctor stuff and all the other stuff. And why would McCabe be acting suspicious and all the, so, look, they'll do it however they do it, but this summation is like 85% science and then sprinkling like some of these other details, but it science, Mr. White, that's what it is.
I love that. Well, Mr. Bederow, any final words from you? We are at our 2-hour mark. You are the king of all kings. You are my favorite voice, and I will miss your voice. And I'm not saying it's over, because, hey, it ain't over. And you have become someone that I very much, I've respected you as always, but I really look forward to being able to speak with you and getting your takes on things. And I know that we'll have, some more days in between here, but this has been a wild ride, and I just wanted to say thank you very much.
I appreciate that, but don't also forget that I have, 3 other trials over the next God knows how long. I say 3 for now. It could be 17 by the time we adjudicate that. But yeah, no, it's been interesting. This is going to be over next week, I think, and barring again, I think shenanigans and tomfoolery and all that kind of stuff. Just as a basic analysis, she'll be going home and hanging out with her parents and friends, I think, next week.
From your lips to God's ears, and I just will let you know that you will always have a place here with me anytime you want to talk the shit, because you're my guy and I can't help it. All right. I'm just want to be your sidekick.
I'm not a true crime, whatever, because, when you do it for a living, I think it's a little different, but I'm sure there's got to be some wacky case somewhere that, maybe not this much of a deep dive, obviously. But there's got to be some, criminal lunacy somewhere that's worth chit-chatting about at some point soon.
For sure. Well, again, you're the best to ever do it. I wish you a wonderful evening, and thank you, Mr. Bederow. I will look forward to watching and seeing your tweets, and we'll be on. Maybe we could talk the shit after closings. Just saying. I'll just throw it out there and see, if you want to go to someone else's house, I get it, but then we could talk a little too.
We'll talk.
Okay. All right. Bye, Mr. Bederow.
All right. Take care. Good night.
All right, loveys. Whew, what a night. Okay. It is 8:05 p.m. We just had attorney Mark Bederow talk us off the ledge and kind of give us all of the information, putting it together, giving us a confidence that we felt. And we were like, oh, okay, go with your gut. This is happening. And we are days away, hopefully, from freeing KarenRead. It has been a pleasure. I love all of your faces. I'm going to be on Court TV at 9:00 if you're free. So bop over to see me probably talking to this guy. Hello, turtle. Where is it? John DePietro, what are you doing here? I shouldn't be allowed on the internet. All right, bye, loveys.